Well, good afternoon, everybody. My name is Sarah Harding. I'm the dean here. It's lovely to see all of you here this afternoon. I want to start with an acknowledgement. Dalhousie University operates in the unceded territories of the Mi'kmaq, Wolastoqey, and Pescotipetl peoples. These sovereign nations hold inherent rights as Aboriginal peoples of these lands, and we each carry collective obligations under the Peace and Friendship Treaties. Section 35 of the Constitution Act 1982 recognizes and affirms Aboriginal and treaty rights in Canada. We also recognize that African Nova Scotians are a distinct people whose histories, legacies, and contributions have enriched that part of Mi'kma'ki known as Nova Scotia for over 400 years. So it's my pleasure to be here to extend a warm welcome to all of you for this 14th Innis Christie Lecture in Labor and Employment Law. So Professor Christie was born and raised here in Nova Scotia. He started his academic career at Queen's University in 1964, and lucky for us, in 1971 he returned to Nova Scotia and took up a post here, where he taught full-time until 2003 and then part-time until 2007. He served as our dean from 1985 to 1991. He was my dean during that time. I graduated in 1989, so he was my dean the entire time, and he was an absolutely marvelous dean. Professor Christie's teaching interests were wide. Labor law and employment law, poverty law, municipal law, administrative law, contracts, commercial law, and professional ethics. He had a leading role in law reform. He was engaged in the Woods Task Force on Labor Relations in Canada in 1967. He drafted the Nova Scotia Trade Union Act in 1973 with former Dean Reed, and the Nova Scotia Labor Standards Code in 1972. He also changed the way employment law is taught in law schools, in part through the influential text, Employment Law in Canada. Professor Christie served in the 1970s as a member of the Canadian Anti-Inflation Appeal Tribunal, was counsel to the Nova Scotia Labor Standards Tribunal, and was chair of the Nova Scotia Labor Relations Board. In addition, he was Deputy Minister Deputy Minister in the Nova Scotia Department of Labor, and served as a member and chair of the Nova Scotia Workers' Compensation Board. He also served as a part-time member of the Federal Public Service Staff Relations Board and of the Canadian Human Rights Commission Tribunal. Professor Christie's career was of the sort that we perhaps all aspire to. He taught, he mentored, and he inspired generations of labor law students across Canada. And his contributions to academic labor law, to public policy formation and administration, to labor arbitration and adjudication, and to legal education are broad, deep, and enduring. He is a remarkable role model, and the Innis Christie Lecture in Labor and Employment Law honors his life and work. We would also like to mention his wife, Jean. Jean was a staunch supporter of Innis and his legacy. She attended every Christie lecture in person or virtually. She passed this past December in 2024, and we extend our deepest sympathies to the Christie family. I know Mike Christie is here, so welcome and thanks for being here. I would like to thank Professor Lee and McHugh Russell for making this lecture happen and for the assistance provided by the faithful Elizabeth, who's still back there. And I know Professor McHugh Russell will now introduce our guest speaker. Thank you.
It's always been a great honor for me to be able to attempt through the Christie Fund, supported by so many members of the labor law community, not just from Nova Scotia, from across the Atlantic provinces, but from across the country. It's been my great honor and pleasure to be able to put together lectures and events in my now 5 years here at Dalhousie University. And one of the small pleasures that I have in bringing together these events and trying to host speakers and participants in symposia to speak on labor law is that someone with a background in labor law, it often gives me the opportunity to spend time with scholars with whom I have some familiarity and background. It's my great pleasure, as well as my great privilege, to introduce our speaker for today, our distinguished visiting professor, Innis Christie Professor Michael Lynk. But let me start with why it's a pleasure to have Professor Lynk here. Michael. In 2007, a partner at a firm I was working in, who I won't name, I'll call him Barry, at the end of the summer asked me to help him write a paper on age discrimination in Canada. And that was a paper that he was going to co-write with Professor Lynk for a labor law conference at Western University. And he asked me, because he knew that I was a bit of an egghead that loved legal research, to help him write his portion of the paper that he was writing with Professor Lynk. And so I spent much of my fall, in the fall of 2008, trying to write the founding portions of a paper that would be useful not only to Barry, but also to Professor Lynk. And I have to say that I was, to mix a metaphor, a little bit too much of a budding egghead to write anything that was particularly useful. It was a great deal of information. I was very enthusiastic, but the result was probably not anything that was particularly useful to either of the other co-authors. But it's always been something that I've enjoyed to say that I almost co-wrote a paper with Professor Lynk, and because he asked Barry to help write that paper, in some sense, Professor Lynk is responsible for me having entered into an academic career, and it remains to me seen whether that's something I should thank him or curse him for. But now to my privilege and the reasons that we're so happy that he agreed to serve as the Innis Christie Visiting Professor this year. Professor Lynk taught at the Faculty of Law, Western University in London, Ontario from 1999 to 2022. He taught courses in labor, human rights, disability, constitutional, and administrative law. He served as Associate Dean of the faculty from 2008 to 2011. And in 2023, he retired as Professor Emeritus. Before he became a professor, he was, we're happy to say, a graduate of Dalhousie University, although he earned his LLM at Queen's, for which we will forgive him. Professor Lynk serves today, having since his retirement, as a labor arbitrator and a mediator. He continues to serve as an arbitrator with the Ontario Grievance Settlement Board. He has published widely on Canadian labor law and human rights law, and he is the co-author, until recently, of trade union law in Canada, and continues to be co-author of employment law in Canada with Lexis. And part of the reason that we're so thrilled to have Professor Lynk here is he really is a scholar and an academic and a jurist precisely in the model of Innis Christie. He is prolific, it's true, and his scholarly work is thoughtful, engaging in the subject matter of labor and employment law with depth, concern, and a sense of justice. But he is also someone who is active, engaged, and who sees the role of the jurist as necessarily one that involves participation in the legal process. Among his many roles in his active legal life is serving from March 2016 as the special rapporteur for the human rights situation in the Palestinian territories occupied since 1967, a position that he served at the election unanimously of the Human Rights Council. In this capacity, he delivered regular reports to the UN General Assembly and the Human Rights Council on human rights trends in the occupied Palestinian territories. Since he completed his term in 2022, he has written about his experiences with the UN in a 2022 book co-authored with Richard Falk and John Dugard, two of his predecessors in the Special Rapporteur role, protecting human rights in occupied Palestine, working through the United Nations. Professor Lynk, Michael's scholarship and reports have been widely cited by the courts, by tribunals, by other scholars and human rights organizations, not least of which include the Supreme Court of Canada, the International Court of Justice, and the United Nations General Assembly. I'm proud to have him as a colleague. I'm happy to call him a friend, and I'm thrilled to introduce him before his lecture today. Thank you so much.
Thank you very much for that warm introduction, Liam, and thank you as well to the Dean for the great welcome to this law school. It's a humbling experience to be here giving the Innis Christie lecture. I think of some of the lecturers who wind up preceding me, including Brian Langell at the University of Toronto, who taught me contracts and employment law here at Dalhousie, and also most recently Professor Adele Blackett of McGill University. Both of them have spoken about central issues concerning Canadian and international labor law, including the distinction between rights and freedoms, and the special place of racial discrimination and racial justice in the Canadian workplace. My lecture this afternoon is going to focus on the freedom of association guarantee in the Canadian Charter of Rights and Freedoms, and pose the question as to why the Supreme Court has had such difficulty in arriving at a large, liberal, and generous interpretation of Section 2D. But just before I begin that, I'd like to say a few words of tribute to the person for whom this lecture series has been named. Innis Christie was my mentor, my law professor, my squash partner, and most importantly to me, my friend. He belonged to a generation of outstanding workplace law professors who took up the torch that was first lit by the great Bora Laskin and put labor law on the map in Canada in the 1960s and 70s and 80s. Throughout his life, Innis made numerous contributions to labor law, some of which were mentioned by the Dean, but I'm going to mention some of this as well. He was a great administrator. He served as both the chair of the Nova Scotia Labour Relations Board and the Workers' Compensation Board, and as Deputy Minister of Labour. He was a sought-after labour arbitrator across the country, whose decisions are still read and followed today. As an academic scholar, particularly through his monumental Employment Law in Canada, which is now its 5th edition, and which I had the great honor of participating during the 4th edition as one of the revising co-authors. He was an academic leader, particularly during his deanship immediately after the Great Fire here in the 1980s in this very building. He was a terrific teacher. I took him in administrative law, I took him in contract law, and of course I took him in labor and employment law as well. And much of what I owe to whatever I've done in labor and employment law afterwards, I owe to him. And finally, look, he was just simply a terrific person, full of emotional intelligence, full of kindness for his students, and a natural leader that you would want to follow anywhere. This lecture series has been a wonderful way to honor such a tremendous legacy, and I'm pleased to see Mike Christie here today representing the family. So, my central argument today is that the Supreme Court, and I'm just going to, there we go. The Supreme Court has done a relatively good job over the past 40 years interpreting the Charter and giving it a relatively large and liberal interpretation. As the court stated was its goal in one of its very first Charter decisions way back in 1984 in Hunter versus Southern News. In each of these vital sections, in each of the vital sections of the Section 2 of the Canadian Charter of Rights and Freedoms, you can see listed there A, B, C, and D. The Supreme Court has provided decisive interpretations within the first decade of this new constitutional era in Canada that held up over the ensuing years. All of these areas, Section 2A, freedom of religion, Section 2B, freedom of expression, Section 1, reasonable limitations prescribed by law, Section 7, life, liberty, and security of the person, and finally Section 15 on equality rights. Within the first decade of the Charter coming into being in 1982, or for purposes of Section 15, 1985, the Supreme Court laid out and poured, if you like, the concrete that hardened with respect to how each of these vital provisions in the Charter of Rights and Freedoms was to be interpreted. And in many ways, interpretations today, 40 years later, are still based on the foundation of what the court wound up doing in the 1980s into the very beginning of the 1990s. And while there have been tweaks and modifications to that framework since, the large and liberal framework has remained in place. Canadians have enjoyed rights and freedoms guaranteed by the Charter, and lawyers and the lower courts have been able to work well with the coherence and the predictability provided by the court in these decisive decisions. So the animating question that I'm going to pose today to all of you, and which I've been struggling with for the last while, is why has the Supreme Court of Canada displayed such enormous difficulties in coming to a settled, coherent, liberal, and purposive reading of Section 2D? Even today, the court is showing signs of retreat with respect to the promise that was initially established 10 years ago through the Third Labour Trilogy. So I'm going to take you through this, and I'm going to divide this into the three Labour trilogies that have been provided by the court, and I provided obviously identification for each of the three eras. The first Labour trilogy, which went from 1987 to 2001 and covered 5 decisions, I call the Age of Denial. The second Labour trilogy, from 2001 to 2015, I'm calling the Age of Perplexity. And the third Labour trilogy, which started in 2015 and continues through to today, I'm calling the Age of Promise and Retreat. So as the introduction to my review of the case law on Section 2D, I'm going to work on 3 premises that I think are important to understand to give you a framework for what has happened. And the first premise I have, which I don't think is going to be disputed by very many people, if any, in this room, is that in order to have a robust and flourishing democracy, we need a dynamic freedom of association provision. Indeed, all we have to think back to are issues involving the Weimar Republic in the 1930s, or lo and behold, the Trump Republic of today, to realize how the coexisting freedoms of expression, assembly, and association, A, are so important to a robust democracy, and B, how those who want to see the end of that kind of democracy to lead us into something much more illiberal would wind up attacking association along with expression and assembly first of all. My second premise is that labor rights are human rights. And I say this by an explicit reference to international law. And this was in fact first marked by a dissent that I'm going to come back to over and over again this afternoon from Chief Justice Brian Dixon in his famous dissent in 1987. The first phrase up there is labor is not a commodity. That comes from the phrase that was put into the Treaty of Versailles in 1919, a section of which wound up establishing the International Labor Court, the International Labor Organization, the ILO, which has been around now for 106 years. It's the longest lasting and oldest organization of the United Nations, and indeed one of its most influential and one of its most functional. We see, and I'm quoting there, I'm sorry for the size of the print, the International Labor Organization's Convention 87 of 1948, which is the Freedom of Association Convention, which says, and I'm going to quote because I'm going to come back to this later on, workers and employers without distinction whatsoever, shall have the right to establish and subject only to the rules of the organization concerned, to join organizations of their own choosing without previous authorization. And then we have in the three documents which create together the International Bill of Rights, the 1948 Universal Declaration of Human Rights, and the two 1966 International Covenants. We have in each of the three well established that everybody, as I read from the Universal Declaration, everyone has a right to form and join trade unions for the protection of his or her or their interests, and everybody has a right to freedom of peaceful assembly and association. No one may be compelled to belong to an association. And those same statements are reproduced more or less in the two 1966 covenants. So it's there, right at the very cornerstone of what we proclaim as international human rights, that labor rights are part of that great family. And the third premise I'm going to put to you has to do with what I call the hydraulic relationship between union density and economic inequality. The argument here is simply that the greater the union density in a society, the lower the levels of economic inequality. And this has been proved over and over and over again by studies by organizations as diverse as the World Bank, as the International Monetary Fund, by the OECD, and so on. And this slide I'm showing now shows you Canadian figures ranging from 50 years ago, where unionization rate was around 32%. This is all in red. It peaked as much as 37% by the beginning of the 1980s, and then it's been on more or less a slow, steady decline to where it is today at about somewhere between 32 to 30%. And you can see the line going in the opposite direction in blue, which is the amount of share of national income being captured by the 1% in our society. So in many ways, I think we can accept that unions are wealth distributors in any particular society. We know from evidence over the last 20 years that societies which have lower rates of economic inequality tend to generate more liberal social education legislation, better health outcomes, lower rates of poverty and absolute poverty, and longer and better life expectancies, and more public spending on issues such as education and cultural facilities. Unions, I must hasten to add, are not the only wealth distributors in our society. Obviously, others that contribute to that would be progressive tax systems, limits on the amount of money that can be spent in election campaigns, and strong public health and education programs. But unions are one of the significant contributors to lower economic inequality in any particular society. These are Canadian figures. I can then show you American figures as well. Sorry, I went one too far. Where the hydraulic relationship is much the same with respect to the difference between relationship between union density and economic inequality. This one goes a little bit longer over the last 100 years, but you can see basically where union rates in red were low, then economic inequality was, in terms of the amount of income going to the top, 10% was higher. As union rates increased after the Second World War through to the 1950s and 60s, that brought down the share of income going to the top 10%, and then the two lines wind up diverging significantly since then. And the third relationship that I want to point out with respect to my third premise is that this was recognized by the founders and framers of the National Labor Relations Act in the United States, which was it came into legislation exactly 90 years ago in July 1935. And in the preamble to what we know today as the Wagner Act in the United States, the Wagner Act also being the framework that we accept for labor laws and labor regulation in Canada, wind up recognizing the direct relationship between economic inequality and union rates as well. The premise of the Wagner Act, which I'm showing you now, goes to this hydraulic relationship, and it was a significant, the significance of the passage of the National Labor Relations Act in 1935 wound up ensuring the massive increase in unionization rates during and just after the Second World War, which continued until the 1960s. Interestingly enough, by 1960, the unionization rate in the United States was around 30%, and it was just under that in Canada. It is now 30% in Canada, and it's less than 10% now in the United States. It's been decreasing by about a percentage a year over the last 15 years, such that unions, except in a few industrial areas, including steel making, and including mining and including auto assembly, has just about disappeared from the face of the American landscape. So now I want to turn to a review of the case law through the three different eras that I've mentioned to you. The key, I think, to this is going to the International Labor Organization and the four specific rights that are laid out in the key conventions of the International Labor Organization. There are four I've listed here. The fourth one, the right to be free from government interference, has not really been an active concern in Canada. So my focus, and the focus indeed of the courts, has been on the first three: the right to organize, join, and remain in a union; secondly, the right to collectively bargain; and third, the right to strike. Now, in examining the course over the last 38 years of how the Supreme Court has viewed various major litigation coming to it, contesting Section 2D and labor rights, I think it's useful to be able to, if you like, put the trends among the three different schools of thought among the Supreme Court of Canada judges. The first would be the judicial minimalists, and we're going to see their largest, if you like, their peak power would have been through the first labor trilogy and to a lesser degree into the second labor trilogy. They had understood, and as we shall see, that freedom of association really only is an individual right. They could not conceive of it as a collective right, and declined as well to provide any collective agreement content to Section 2D, and had nothing really of use that they could find in international labor law. The second school are the judicial formalists, who really emerged with the second labor trilogy, who understood Section 2D. My apologies. Move it up there. Who understood, who rejected the concept of Section 2D rights only in the form of individual rights. They did accept the collective right approach to freedom of association and to labor rights. But what I'm going to suggest they did was in a restrictive and formalistic fashion, sometimes in a rather incoherent fashion. They certainly dominated the second labor trilogy, and they remain influential today. And the third school would be the judicial liberals, who understood freedom of association obviously in the large and liberal fashion that was first deemed by the Supreme Court back in the mid-1980s, even before we got to interpretation of Section 2D. They accept the important role of unions in a democratic society. They've anchored their understanding of freedom of association in the international labor law and international human rights law, and they've adopted the argument that labor rights are human rights. They were influential in the creation of the third labor trilogy, but I'm wondering now whether or not their day is done. I say that in part because we're 10 years ago when the Supreme Court wrote the third labor trilogy in January of 2015. There were 3 of the 9 judges on the court had deep experience and backgrounds in labor law: Justice Abella, Dalhousie's own Thomas Cromwell, and Louis LaBelle. All three of them are retired, and none of their replacements have come from a labor law background. So I'm going to take you now through this. So we're now going to turn, if you like, to what I call the age of denial, which began with the first labor trilogy in 1987 and went until 2001. And I should say, out of interest, because I was both a labor law professor, but also a constitutional law professor as well. Of the four professors at my law school, Western Law School at the University of Western Ontario, I was the only constitutional law professor who even taught Section 2D in first year to my constitutional law class. All of my colleagues, and this resulted in lots of excited conversations during lunch breaks in the faculty room. And I would ask them, 2D, or freedom of association, is a fundamental right, and in Canada recognized as a fundamental freedom. Why don't you teach it in constitutional law? Oh, it's too specialized. You teach it well in constitutional law, Link. It's really only a labor law right, and that therefore it seems pretty thin to us to want to spend any time with this. Oh, we just don't have the time. But it always had a low ranking with respect to this. I have no idea how it's taught or not taught here at Dalhousie, but it strikes me as a shame that I could never convince my colleagues at Western to ensure that there was at least 2 or 3 classes in their charter portion of their constitutional law course that would have dealt with Section 2D. So now I'm going to be giving you a quick constitutional law 101 conversation on this. So we start off with Alberta reference in 1987, and this and 2 other cases coming from Saskatchewan and coming from the federal jurisdiction were 3 cases that came to the Supreme Court and argued in 1986. These were the first cases to invoke Section 2D, and the main case where the bulk of the reasoning was laid out was an Alberta reference. In this case, it was a challenge by trade unions in Alberta to legislation passed by the provincial legislature there, which had removed collective bargaining rights and the right to strike from various public sector workers. And the question obviously in front of the court was what does Section 2D protect? How broad is it? Does it protect and constitutionalize a right to strike and a right to collectively bargain? And on a 4-2 split, the Supreme Court ruled that there was no right to strike and there was no right to collectively bargain that were protected in the Constitution. While Mr. Justice McIntyre wrote for himself, his very lengthy decision also reflected the views of the other 3 judges in the majority. And here you have him, in fact, initially in the first 4 or 5 pages of his decision, you have him singing, if you like, a hymn to the importance of freedom of association and how integral it is to modern democratic societies. And then the tone changes, and I'm not going to take you through all of this, but essentially he ruled, his ruling, along with the other 3 judges, was that the Charter only protects individual rights, even though it says freedom of association. There's no collective content to it whatsoever, and you cannot exercise a collective right to, say, the right to strike if there's no individual right to strike in these sections. So with that basis, he ruled that the right to strike and the right to collectively bargain were not protected. He went on to say that the right to strike had really only been around as a right, a statutory right, since the 1940s, and therefore there wasn't enough time in Canadian law to have that gravitas of justifying constitutional protection. More importantly, what he said was that industrial relations, he said, is a delicate socio-economic issue which is best left to the legislatures to determine the appropriate balance. We, the courts, he said, are poorly equipped to duplicate industrial relations and try to adjudicate there. I'm going to come back to that at the very end of my lecture today and go through where he winds up having taken this reasoning from what I call some of the charter skeptics at the beginning of the charter era. I would not ordinarily show you a dissent, but this is the dissent by Chief Justice Brian Dixon. And this is not only, I think, the most famous and influential dissent in the modern charter era, it's probably the most influential and important dissent ever issued in Canadian judicial history over the last 150 years. And the reason we'll see why this became so influential in some of the decisions to come. Dixon relies upon international human rights law and international labor law as an important source of interpretation. He talks about the profound importance of freedom of association as a cornerstone in a democratic society. He talks about how associational freedom with respect to civil society organizations, church groups, political organizations, and trade unions, and the rights of minorities to be able to organize themselves as being part of that essential middle space between corporations and governments in order to be able to hold both accountable. He goes on to make this profound statement about work being one of the most fundamental aspects of a person's life, which gets quoted over and over and over again in subsequent decisions. He talks about the role of trade unions and how they play a vital role in contributing to democracy with respect to that. So on that basis, in his dissent, he rules that Section 2D would have protected the right to strike and the right to collectively bargain. So let's hold on to that image of what he said. I'm going to skip the next 4 decisions that came in the labor trilogy and just take you right to 1999 with the Delisle decision. And we've already known from Alberta reference that there is no right to strike and there is no right to collectively bargain. What about the third right, the right to organize that is recognized by the International Labour Organization? This had to do with RCMP officers who were statutorily prohibited. They weren't included in the Canada Labour Code. They were statutorily prohibited in the federal public sector legislation from being able to unionize. Virtually every other police force in the country had formed a union by 1999. So a Quebec RCMP officer challenged the statutory prohibition, goes all the way to the Supreme Court, and the court holds that the right to organize also is not recognized by Section 2D. And the reasons are given by Mr. Justice Bastarache, who basically says, look, I see that virtually every division of the RCMP in the country has been able to form a voluntary association. I don't see any interference, and they can make their employment claims to their employer. They're not being stopped from doing that. Therefore, I don't see where there's any interference with respect to their right. And then he says, he goes on to say, or repeat what the judges had said 12 years previously in Alberta reference, that this is an area where the courts ought to defer. Even though Section 2D is in the Charter, labor relations is too delicate and too important a process to be litigated in the courts. The courts were told to stay out back in 1945. We should continue to wind up obeying that. And therefore, in essence, and this decision came out, I think, the week I began to teach at Western University. And I think all of us who were in the academic labor law community concluded that this was the end of Section 2D. No right, and all 3 of the rights have been pronounced upon, all 3 of the rights have been rejected by the Supreme Court. We were just going to forget about constitutionalization of labor rights and go on to teach arbitration law and labor relations board law. But, quite unsurprisingly, there are 3 decisions I'm going to briefly take you through under the second labor trilogy, and every single one of these 3 decisions wound up, I was going to say surprise, but the better word would be astonish. I think the labor law community in general, and certainly labor law academics in particular. This case, Dunmore, had to do with an exclusion of an occupational group from the ability to be able to unionize under ordinary labor relations legislation. A union, the United Food and Commercial Workers, was seeking to represent them, and they wanted to be able to fight this exclusion under Section 2D. They had huge odds against them. I mean, who would have thought that the Supreme Court was willing to change its mind with respect to what it said 12 years before, 14 years before, and then 2 years before in the Lyle decision. So the question was, should agricultural workers, which really are at the very bottom of the totem pole with respect to labor working conditions and rights in Canada, should Ontario agricultural workers be allowed to unionize? And the answer was yes, but. We have the absolute exclusion was infringed Section 2D and could not be saved under Section 1. The judge again, just like 2 years before, was Mr. Justice Bastarache. So then you were confronted with, what changed his mind so quickly? Why, if he said RCMP officers didn't have the right to unionize and there was no right to organize under the Section 2D, why was there suddenly this new door opening with regards to this? So he distinguishes Dunmore from Delisle. He points out, RCMP officers have the right, as he had said in Delisle, to be able to band together, and the RCMP wasn't interfering with that. He said, but farm workers are incredibly vulnerable. There was a very well put together affidavit by Judy Fudge, a leading labor law scholar in Canada, on behalf of the union that was challenging this. And she pointed out to the particular vulnerability of farm workers. So all of a sudden you see Bastarache, who, after all, remember, was the Supreme Court judge from the Atlantic provinces, but more importantly, he was an Acadian. And he had been involved in Acadian activities in New Brunswick for much of his professional life. He understood, if you like, minority rights. He understood the issue of vulnerability. And these are only speculations on my part, but I think this had a great deal to do with him understanding what to do with in the Dunmore case. So he begins to disagree with some of the precepts of Alberta reference. He says Section 2D is fundamentally a collective right as well as an individual right, and disagrees with Alberta reference on that. And he sets up this two-stage analytical process where he brings in substantial interference, or substantially interferes. I want you to keep that in mind. He points, again, with reference to the Dixon dissent from 14 years before, to the importance of international labor law and the ILO Convention 87. And he acknowledges that workers are, and this is one of the most important phrases coming from Dunmore, he acknowledges that workers are rarely ever able to, if you like, exercise the freedom or the right to organize and the right to collectively bargain unless they have statutory frameworks which grant them that. Otherwise, they're in a bullpit with a much superior organization, the employer. And he says, I believe that the exclusion of agricultural workers from the Labour Relations Act of Ontario substantially interferes with their fundamental rights, and he sends it back to the Ontario legislature. Now, what he didn't do was actually say they should be put in there. He left it to go back to Ontario, and we'll see the problem of that in a second. So whenever I'm teaching this particular case, I always think to myself, and share this with the audience, that the Supreme Court in this case could have done more. Okay, no more puns. So the next important decision, and I remember where I was when this decision came out in 2007. Bruce Archibald and I were in Montreal with a meeting of labor law academics across the country to put together the next version of the casebook. And we knew that the decision was coming out at 10 o'clock in the morning. Bruce figured out that there was a print shop right across the street from where we were meeting at McGill. We went across there. We were, I'm sure, the first 3 people in the country to run the decision off. And then we spent the rest of the day, which should have been going towards see you later, Jill. To see the next edition of the casebook. No, instead of picking apart this, if we were surprised that the Supreme Court opened up the door somewhat with the Dunmore decision, we were astonished about how far they went with BC Health Services in 2007. Again, all of us thought this was probably a hopeless cause. And this was a case where a large number of public sector collective agreements in British Columbia were stripped apart by legislation brought in by the new Liberal Party government in British Columbia. The unions were only given, I believe, 20 minutes notice. The legislation was passed within 3 days. There were huge demonstrations around the province opposed to that. The unions then decided to fight this with the Supreme Court, using Dunmore as a possibility that there might be a right to collectively bargain after it having been receded 20 years before. And lo and behold, the appeal by the unions in 2007 wound up being allowed, and for the first time ever, the right to collectively bargain winds up being accepted by the Supreme Court by a 6-3 majority. And the lead decision was written by Chief Justice McLaughlin along with Louis Lebel. They built on Dunmore. They dismantled the reasoning of Alberta reference. And this is another thing just to keep in mind. Show me any other decisions which have been in the Charter era on any other sections of the Charter where the Supreme Court has actually overturned an earlier Charter ruling, actually said it was wrong. I have a difficult time trying to think of any decision. Supreme Court has done this on several occasions with respect to Section 2D, which again goes to how distinct and different its treatment of Section 2D is from virtually any other section. So again, this was a virtual hymn to the breadth of freedom of association in general, and to the right to collectively bargain in particular. It endorses what Dixon said 20 years before with respect to international law. They attribute all kinds of charter values: human dignity, equality, liberty, autonomy of the person, enhancement of democracy, are promoted by Section 2D, and the right to collectively bargain. It's said, importantly, that the Charter does not have any no-go zones for listed constitutional rights, and that we have to interpret Section 2D in the same breadth as we interpret other fundamental freedoms in the Constitution. They endorse the collective nature of it. They adopt what the Dunmore standard of substantial interference, something, as I said, I'll come back to later. And then they say, which I think is laying a trap for themselves, they say the right to collectively bargain protects a process, not a particular outcome. It also doesn't protect any particular model of industrial relations. Now, what I'm saying, I think here, is that the decision by McLaughlin and Lebel is a mixture of judicial liberalism and judicial formalism. And we'll see this, I think, come together a little bit later on with regards to this. So we're now, I suppose all of us who are in labor law academics are thinking we're now in labor law heaven. We have this extraordinarily wide endorsement of a liberal reading of Section 2D. We don't tend to look at some of the pitfalls in Dunmore, and particularly in BC Health Services, but we think this has ushered in a whole new era. And then we come 4 years later to the third and last decision in the second labor trilogy, which is Fraser. Fraser is a rerunning of the Dunmore decision. After the Supreme Court said in Dunmore in 2002, Ontario, you have to find some way of giving freedom of association, and particularly freedom to organize, the right to organize, to agricultural workers. And the Mike Harris government then passed this legislation called the Agricultural Employees Protection Act. The subtitle of that was "The Supreme Court of Canada Made Us Do This Act." And it gave farm workers, it didn't give farm workers what we would normally expect in terms of being able to form a union, be certified, have the employers have to bargain with them, requirement is to bargain with them, and bargain in good faith to reach a collective agreement. All it required of employers was to listen to any written or oral submissions or complaints that farm workers would have with respect to their working conditions. They had to read them. They didn't have to reply to them. They didn't have to bargain in good faith. They didn't have to come to any sort of agreement with them. They didn't have to do anything that we would ordinarily expect within the realm of labor law and industrial relations. All the employer had to do was simply to listen. And the trade unions that were trying to organize the farm workers in Ontario, said this excludes the essence of modern labor relations, and they went to the courts. And they went to at the Court of Appeal in Ontario. They actually won on a 3-0 decision that this legislation was in violation of Section 2D. The Court of Appeal in Fraser had based its decision on BC Health and on a liberal reading of Dunmore, but also a liberal reading with respect to international labor law and international human rights law as well. Interesting enough, the Chief Justice at the time of the Court of Appeal in Ontario was a well-known management side labor lawyer, former management side labor lawyer, Warren Winkler, and who had written the decision. It now comes to the Supreme Court, and the Supreme Court rules on an 8-1 ruling to overturn the Court of Appeal in Ontario, and to find that the legislation in Ontario with respect to the agricultural workers was not in violation of Section 2D. And Fraser, I have to say, I'm not going to say I've read every single constitutional decision in the Charter era, but I've read a great deal of them, having been a constitutional law professor, that this is probably within the top 2 or 3 of being the most incoherent decisions I think ever issued by the court. And I think the court, in retrospect, particularly with how quickly they overturned, they veered in a direction different from Fraser, wound up agreeing. Within a year of this decision coming out, there was a 300-page book that came out of 12 essays condemning the decision. I can't recall any other recent decision by the Supreme Court has ever attracted a book so quickly and so critically of this decision. So among the rulings that were made by McLaughlin and LaBelle was they had narrowed the scope of the meaning of BC Health Services only 4 years after it had been written. It said that the AEPA did permit employees to band together to present their requests to employers. Therefore, I think since the employers had to listen to them and even listen in good faith, that was sufficient to pass constitutional muster with regards to this. The court then went on to raise what the threshold was to find a Section 2D breach from substantial interference all the way to effectively impossible, that it was effectively impossible for someone to be able to exercise their freedom of association. And they also said that the freedom of association was a derivative right, not a freestanding fundamental right. Please keep those in mind. I won't take you through all the rulings, but I will take you through Bella's, because again, Bella lays the groundwork for what's to come. She's the only judge of the 9 to dissent with respect to this. And she says that the Agriculture Employees Protection Act does violate Section 2D. It does substantially interfere with the right to collectively bargain by not protecting meaningful process of collective bargaining. She said this is nothing like what any union would have to face under a statutory protection with respect to what they present to the employer. The employer then has to respond back, and they have to negotiate in good faith till they reach a collective agreement or embark upon industrial action, but always with the purpose of trying to reach the agreement. She noted that between 2002 and 2011, not a single collective agreement had ever been reached between agricultural workers and their employers under the new legislation. There was no basis of equality between employers and employees with respect to that, and it wasn't saved under Section 1 because it wasn't minimally impairing of farm workers' right to organize, nor their right to collectively bargain. So, as I said, we were surprised when Dunmore came by. We were absolutely astonished by how broad the Supreme Court had taken the freedom of association with respect to BC Health Services. And then having seen BC Health Services and having seen the decision in Fraser at the Court of Appeal, then I think we were all absolutely astonished that the Supreme Court wound up coming up with this decision. Nobody saw this coming. So now we turn to the third and most recent of the labor trilogies, and I call this, as you will and you'll find out why. The age of promise and retreat. And I'm going to divide this under the three different headings: the right to organize, the right to strike, and the right to collectively bargain. Beginning with the right to organize. And here we have mounted police. This is a relitigation. If Fraser was a relitigation of Dunmore, then mounted police was a relitigation of the 1999 decision in Delisle. So in the aftermath of Delisle, the federal government allowed RCMP members to have internal elections within the framework of the RCMP, where they could elect if you like, representatives who could speak to complain about working conditions. But that wasn't collective negotiations. There was a grievance process that was now established, but the final decision maker wasn't an independent arbitrator, but it was the RCMP commissioner. And so those who followed in Delisle's footstep said, this is not sufficient. And they again went to the Supreme Court of Canada with regards to this. Interest disclosed. I wrote an expert opinion for the Mounted Police Association with respect to this. And basically the government's argument was, we're doing nothing any different from Delisle and Fraser. I mean, how is it that this case has any legs whatsoever with respect to this? The Supreme Court actually held, and again surprising us, that there was a right to organize, and this right to organize wasn't being met by having this internal SRRP system in the RCMP. So the lead decision was written by McLaughlin and LaBelle, who write, I think, probably a fairly extensive mea culpa from what they had said in Fraser 4 years before. And they reiterate, they go back to the Book of Genesis, which is the Dixon Descent and Alberta reference, and they wound up reiterating that the charter must be interpreted in a purposive and generous fashion. They correct and they overturn a number of the statements they made in Fraser. They take away substantially impossible, and go back to substantial interference. They say freedom of association is not a derivative right, and the first labor trilogy is truly dead, and Section 2D does encompass collective rights. So it's not only saying that the first labor trilogy is dead and buried with 50 nails in the coffin, it's also suggesting there's not a lot left of the second labor trilogy. But, and this is, keep in mind, the hidden time bomb in all this is that they don't expressly overturn the Fraser decision from 4 years before. So they do say now that the right to organize and the right to collectively bargain are robustly protected by Section 2D, and they overturned Delisle in light of what they had said in BC Health Services and a little bit in Fraser. So all of a sudden we've got this expansive definition with respect to the right to with the right to organize. Now we turn to the right to strike, which is embodied in the Saskatchewan Federation of Labor, which came out a week later from the Supreme Court. And here we have a series of laws passed by the provincial government in Saskatchewan, which restricted the ability of public sector workers who were deemed in a very extensive definition, a very broad definition of what is essential, from striking. And there was no meaningful mechanism to wind up addressing any bargaining impasse that was in this particular legislation. The Saskatchewan Federation of Labor winds up challenging this, and the Supreme Court, led by Bella, finds this was also unconstitutional. And this is the first time that the right to strike is in front of the Supreme Court since its ruling in Alberta reference 28 years before in Alberta reference. She finds that the right to strike is an essential part of the collective bargaining process. It equalizes power at the bargaining table. It's essential in order to realize charter values of dignity, equality, and enhancement of democracy. I don't think that the union lawyers arguing Saskatchewan Federation of Labor could have actually asked for much more. She reiterates once again Canada's international obligations, and she uses international labor law to determine that the right to strike is a fundamental right. She again endorses Dixon's dissent from the book of Genesis. She goes on to say that governments do retain the ability to limit or prohibit strikes if they provide meaningful substitutes with respect to interest arbitration that are fairly designed. So she finds that this violates Section 2D. It's not saved by Section 1. This is one of the cases where I'll point out what the dissent was in this particular case. And this is Rothstein, who really is an exemplar. He's, if you like, light from a dead star, in that he comes from the judicial minimalists from the first Labour trilogy. And you can see who's actually signed on to the opinion with him. He says that the right to strike should not be constitutionalized. He wants to go back to the way, to the arguments of McIntyre, that it's better the courts stay out of Section 2D and the constitutionalization of labor rights altogether. If we do wind up creating rights for labor, this creates a one-sided emphasis, he says, on workplace justice, and he thinks that the majority ignores its own ruling in Fraser, and he wants to overturn BC Health Services, even though that was not argued in that case there. And the third right, the right to collectively bargain, is a little more murky. And I understand why this is. Of the three rights that we're talking about, the right to organize, the right to strike, and the right to collectively bargain, to my mind, the one that's most important for the industrial relations community in general, and for trade unions in particular, would be the right to collectively bargain. Workers don't join unions for the sake of joining unions. Workers don't join unions in order to go on strike. They only utilize the right to strike in order to get a better bargain with respect to what's going on at the negotiating table. So this, in many of ways, the right to collectively bargain is the first among equals in my mind. And I'm not going to spend very much time with the Meredith case. It's a very odd case, and it's very hard to understand why the Supreme Court even wound up accepting it, because at the time, this has to do with the RCMP, and the RCMP officers having their wages rolled back through austerity legislation that was introduced in the Harper government in 2011, 2012, I believe. But the Supreme Court takes this on, and it treats the RCMP as if they were unionized, even though there was no collective bargaining, there was no union, and there was no collective bargaining that was going on. And says that this wage cap doesn't interfere with Section 2D. I think in part this was probably fairly poorly argued in front of the court because there were no unions to wind up arguing this particular case. So McLaughlin and LaBelle, on a 6-1 majority, they reaffirm the right to collectively bargain, but they say this is an unusual case not fought by a union. But in any case, they found that the austerity legislation did not substantially interfere with the right to collectively bargain. Justice Abella wound up dissenting, and she said there was no meaningful representation by the RCMP officers to be able to make representation to Treasury Board. Therefore, there's no violation of Section 2D. There is a violation of Section 2D and no Section 1 justification. So what did the third Labour trilogy wind up establishing? I've got 8 layouts here. All of which I think are probably fairly significant. All 3 labor rights are now protected, at least on paper, by the Supreme Court. The right to organize, the right to collectively bargain, and the right to strike. They've clarified that the right to freedom of association, the standard of interference is substantial interference. But they've never provided, and I'll come to this in a second, as to the rationale for why this threshold is any different from sections 2A and 2B. They clean up some of the sloppy thinking on the freedom of association, particularly from Fraser, but they don't overturn Fraser, which you'll see in a second winds up creating current problems with respect to us. The dissent by Dixon from Alberta Reference remains, is now strongly affirmed, but as I say, Fraser now still remains good law, despite the contrast with amount of police. But the last case I want to point out to you, this is my last of the decisions, is why I call this age the age of promise and retreat. This was a decision that came out last April from the Supreme Court. It had to do with a union wanting to represent first-line managers at a variety of publicly owned casinos in Quebec. the labor legislation in Quebec forbade managers from organizing. So they were challenging this on the basis of a section of the right to organize that in a number of other jurisdictions in Canada, including the federal jurisdiction, including the Ontario jurisdiction, first-line managers have the right to be able to unionize as long as they're in a separate union from the workers that they're unionizing. And this goes to what I had quoted before from ILO Convention 87, which said that all workers without distinction whatsoever. It gives a broad definition of the right to unionize from a range of employees. So they won. The union won the constitutional argument at the Labor Tribunal. It was overturned by the Quebec Superior Court, but the tribunal decision was restored by the Quebec Court of Appeal, and then goes to the Supreme Court. And on a 7-0 decision, the Supreme Court rules in 3 different concurring judgments to allow the appeal and to quash the ruling coming from the Labor Tribunal. In other words, that the exclusion of first-level managers does not violate Section 2D. And the lead decision was written by Mr. Justice Jamal. He applies the standard tests coming from the 2 steps in Dunmore, but he then goes back to what I've always thought was problematic. He says, you can see there about 2/3 of the way through, that the right to meaningful collective bargaining does not guarantee access to a particular model of labor relations. This was arguments used by the Supreme Court in Fraser and also in BC Health. I think this is problematic. This is, I think, the essence of formalistic thinking with respect to this. It's not whether or not the Constitution and Section 2D would constitutionalize the Wagner Act. It's whether or not there's protection for the 3 rights that are laid out in international labor law that we've accepted into Canadian labor law. And you can see here, there's no reference made to international law. As I've found, when international law is mentioned and endorsed and relied upon, that invariably means it's being done so by what I call the judicial liberals. If it's ignored or said it doesn't really mean what it says it means, that's usually by a statement made by the judicial minimalists or the judicial formalists regarding this. This, by the way, the other thing I just want to point out, of the 12 decisions that I'm looking at, and you haven't seen all of them, but the 12 decisions that are part of the 3 labor trilogies from 1987 now to 2024, the first 11 decisions, none of them were unanimous. There were always strong dissents going one way or the other. This is unlike virtually any of the other major freedoms or rights under Section 2 or under Section 7 or under Section 15, where a lot of them eventually wound up attracting a unanimous majority for this. This is the very first decision where there's unanimity with respect to the outcome, and it happens to be a restrictive outcome as well. So that's why I'm thinking that we may be in an age of retreat with respect to how broadly we look at Section 2D. So let me just clean up with this. Some of the problems. First of all, I want to talk to you about the Charter and labor law. The expansive definition on the use of labor law, the use of international law to be able to interpret the Charter comes from Dixon's dissent back in 1987, where he said in a phrase that's one of the most quoted phrases in the modern Supreme Court era, "I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents which Canada has ratified." And the irony is that in the years after Dixon's decision, his dissent in Alberta reference, that particular clause was used by court majorities in the Supreme Court in all of these areas: extradition law, environmental law, refugee law, Aboriginal family law, and laws on terrorism, to reach a Supreme Court majority borrowing interpretations coming from international law with respect to that. The only area where it wasn't used was labor law, ironically enough. And even now, we have divisions. We've got this broad definition of international labor law that was repeated by Bella in Saskatchewan Federation of Labor, essentially agreeing with the thrust of what Dixon had said. Yet in the most recent decision, in one of the minority concurring reports, they talk really about how international law is limited and should not be widely relied upon. Another unresolved problem I find is, why is there a different, higher standard for Section 2D, substantial interference, than there is for Sections 2A and 2B? You see this in Section 2A, freedom of religion, one of the path-breaking cases of Edwards' books, where it said that if the interference is more than trivial or insubstantial, then there's a breach found of Section 2A, and then the whole analysis goes to Section 1 with the onus on the government. Same thing is true with Section 2B on freedom of expression. Once there's any kind of state interference with freedom of expression, a violation is found of Section 2B, and then the real workings and the real load winds up going to Section 1. But that's not so with Section 2D. We have it starting from here of a substantial interference. This is BC Health borrowing from Dunmore. And then it's even raised higher in Fraser of substantially impossible before they bring it back again to substantial interference. I don't understand, and other labor law scholars don't understand, why there's a difference. The Supreme Court has never intellectually explained why it poses a higher threshold for 2D than it does for 2A or 2B. And I can't think of a good one, even trying to put my feet where they are with respect to this. So my conclusion, I think, is that the Supreme Court, I think, on each of these four grounds, has been unable to try to provide, I think, most importantly, a large and liberal reading of Section 2D that establishes coherence and establishes predictability, as it has with the other two freedoms, as well as the other rights in the Constitution. Secondly, it's unable to accept labor rights as human rights. There is a stated commitment to it, starting with Dixon, repeated by Bella in SFL, but now seeming perhaps going to wither again on the vine after Quebec Casino. Thirdly, why is there a more onerous threshold? And fourthly, the inability to establish the role of international labor law and how you read Section 2D with regards to this. I'm just going to conclude with this. There are three different schools with respect to how you, among labor practitioners, on how you view the issue of the Charter and the constitutionalization of labor rights. Two of the three schools would argue against this ever happening. The first I would call are the labor cynics, and I say that not to disparage them. I've just finished reading this excellent book called Unions in Court, Organized Labor and the Charter of Rights and Freedoms, who basically argue from a left-wing point of view that the courts are always going to be class biased, the courts are never going to give you a fair shake, and you should rely upon militant union action to be able to gain better working conditions and better societies. And I came across this a little while ago, which is an interesting expression from a statement from a little over a century ago by the chief of the commercial court in Britain, which I see that the so-called labor cynics will often cite as a saying, judges are of a different class than labor unions. Why would you ever think you're going to get a fair shake from them? A second view, which I would call the charter skeptics, comes from people like Harry Arthurs or Paul Weiler, two giants from the 1960s and 70s right through the 1990s in Canadian labor law. Their basic argument was, when they grew up as young lawyers, having seen how the Wagner Act of Canada was formed, the whole purpose of the Wagner Act was to remove the labor decisions and labor litigation from the courts, to create their own independent labor arbitration boards, their own independent labor relations boards, because the courts couldn't be trusted. The courts just didn't get it. And they're saying, if we went through such an arduous process with bringing the Wagner Act north to Canada, why would you want to trust the courts all over again with respect to trying to get it right with respect to constitutionalization of labor rights? You're just wasting your time with respect to this. They won't get it. And you see how that view was adopted early on by some of the judicial minimalists, such as McIntyre and Bastarache, who said the courts have no place in trying to decide these kinds of issues. Let's leave it to the experts. And then you have a third point of view, which Judy Fudge is someone I think has probably moved across the scales with respect to this. But she points out something quite interesting, is how obviously the necessity or the need and necessity now of unions going to the courts to try to build constitutional protections mostly are defensive battles, both to preserve what they wind up having and what they've been able to achieve through political and economic power, with the hope that the courts can wind up resolving these. And keep in mind, we are in a very difficult and very interesting period of time now, where in Canada, we've had 4 major federal strikes in the last 9 months, ended by ministerial fiat. Port strikes in Vancouver, WestJet strike, 2 national rail strikes, and then the postal strike. Not even solved by going through back-to-work legislation in Parliament, which at least has a democratic flavor to it, but by the unilateral use by the Minister of Labour of a completely obscure piece of section of the Canada Labour Code I'd never even heard of before this past year, Section 107, where he can direct the Industrial Relations Board to basically find that the parties have to end their industrial dispute and enter into interest arbitration. There's a lack of democracy with respect to that, but there also is this, and there will be more constitutional challenges with respect to the abrogation of the right to strike and the right to collectively bargain with respect to this. So we're still in an era where we don't have a very good idea in the labor relations community where the parameters are with respect to what freedom of association winds up meaning with respect to this. So I wish I had better answers with respect to why the court has been so inconsistent. I don't want to say incoherent, though I think there are periods of incoherence that they've gone through. But certainly with the inconsistency of how they treated Section 2D is a blight, I think, on the many accomplishments that the Supreme Court has made over the past 40 years. There was a great study done about 10 years ago by 2 American constitutional political scientists who examined a number of leading modern constitutions in the world. And they said that Canada is a constitutional superstar with respect to not only how modern its constitution is and how broadly it is, but the quality of the decision-making coming from the Supreme Court. And what I'm pointing out to you, I think, is an exception to that. I think the Supreme Court has earned lots of accolades with respect to this. But on one of the most important areas, I think they've fallen apart. Thank you very much for listening.
Professor, thank you so much for giving us this really comprehensive view, both of the presentation and the history. If you're willing, hopefully we can take 10 or 15 minutes. If anyone has any questions or follow-ups they might like to ask you.
Why would there be any questions? I think I'm answering it all.
That's it.
I wonder if you can talk maybe a bit about whether you think that the confusion being sowed by the Supreme Court has limited the normative power of the Supreme Court to say no, this is that labor rights are fundamental rights, and that if that is kind of emboldened governments to kind of constantly we see this situation where the Supreme Court says, okay, the right to strike is protected by the Constitution, but then governments are still consistently violating that right.
Mm-hmm.
And then I understand strategically why they do it, but I wonder if there's an element where they think it's not going to be taken, it's fine, because as a society, we don't really think of labor rights as fundamental rights. You can see how the Supreme Court kind of like maybe suggest that that's like there's like a, what am I trying to say? There's like a discussion between what our society thinks of as labor rights, which not fundamental rights, that's kind of privileges,
Yeah.
and what the Supreme Court is doing, and maybe the Supreme Court reflects kind of a confusion in our society in that way.
You know, I recall after the Supreme Court came down with the Saskatchewan Federation of Labor exactly 10 years ago, thinking, this is good. It's going to put a stop on provincial and federal governments from the narcotic effect of wanting to pass back to work legislation. Back to work legislation isn't banned by SFL, but it should have made them much more careful in when they do it. And when they do it, they've got to make sure they've got comprehensive and fair substitution through interest arbitration. That's what I thought was going to wind up happening. And you know, the message coming from Abella in Saskatchewan Federation of Labor is, we have to pay attention to what international law in general and the ILO in particular wind up saying with regards to what are essential services, when can you intervene. It can't be simply because there's public inconvenience. It has to be because there's a substantive threat to health or safety or security of the population. And I've not seen that repeated since then on this issue, which makes me think that you know, by the time 2024 rolled around, that the federal minister of labor from a Liberal government, you know, thought he had a fair amount of wind in his sail, to use a Nova Scotia expression, to wind up issuing these 4 different 107 orders directing the Industrial Relations Board to order an end to the strike with respect to that, not even going through the agony of a debate in the House of Commons and the Senate with respect to back to work legislation. So that's the puzzlement I have with respect to that, and I'm not sure if they sense that there's a different Supreme Court now. I do think the Supreme Court now, not only on labor issues, is a more conservative court than it was perhaps 10 years ago, which is, particularly if you compare us to the way in which the courts evolve in the United States, it's kind of surprising that after 9.5 years of a Liberal government, which appoints judges to the Supreme Court, and has appointed almost all of them, it's a more conservative court than what we had under Stephen Harper, who appointed a fair number of his own justices to the court. But that's where I think we are. I think, as I said, part of it may be explained by the fact there's no labor specialist on the court to be able to raise that voice. And there's no particular appreciation, perhaps, or they're willing only to read more selective parts of the more, I think, challenging parts of of some earlier decisions to come to their conclusions, as we saw in the Quebec casino case.
Thank you.
See, I told you, I answered everything.
I have a question. Is one of the unresolved issues, do you think, that Canada has not further developed, you know, in light of our international obligations, what you addressed at the very beginning of the freedom not to associate, freedom not to be in a trade union, which is kind of more developed in Europe, that right? And is it just that those cases aren't being advanced, or what do you attribute that to?
Recall that in Canada, we've dealt with freedom not to associate in a couple of Supreme Court of Canada cases. We've done that in Levine, and that case really had to do not so much with membership in a union, but how my dues as a non-member were being used for causes I don't believe in. And then we had advanced coring and cutting by the Supreme Court, which also dealt with a situation in Quebec where if you were going to be in the Quebec construction industry, you could choose which of the 5 unions you're going to be in, but you had to belong to one of them. You had no right, you had no ability to find employment in that sector without belonging to one of the unions with respect to that. So I think, and in that case, there were four different decisions among the 5 judges, among the 9 judges. And I think the 4 in dissent would have said there is a freedom not to associate. The 5 gave 3 different reasons as to whether or not the requirement to associate was either violated Section 2 or not. Some said it didn't violate it, and some said it did, but was justified by Section 1. So you could say from advanced coring and cutting, we still haven't finally come to a conclusion on that, and I'm not aware of any recent cases since then on the right or the freedom not to associate with regards to that. And you're absolutely right when I pointed that out under the Universal Declaration of Human Rights. So there is a freedom not to associate. And I think what the court did was try to place that within the concept of the Wagner Act, even though they said they weren't doing that.
Thank you.
Fair enough. I'm gonna ask a question. No, I want to. I just want to put one. And I'd love to hear your thoughts. I want to put an explanation on the table. It seems to me, if I can pull out a few moments, both from the majority in the earlier decisions, as well as to some degree the majority in the later decisions. As was expressed earlier, there's that real reticence, including in Rothstein and Wagner's dissent in Saskatchewan Federation of Labor. There's real resistance, concern, anxiety from the court, not just to not interfere with legislative decision making, but there's a real resistance and anxiety about legislation, or about judges dictating the form that legislation in fact has to take, right? And you see that anxiety in cases around, for example, the regulation of sex work. That same concern where we're not going to tell you how to do it, but the way you have done it is violating the rule. And so, much more than many of our colleagues, I'm somewhat sympathetic to the Society of the Casinos case, because it feels like a large part of what is driving the majority decision in that case is this desire not to constitutionalize a particular model of labor relations. And so I wonder, to what degree, when we see this constant dancing around and how full are we going to make this right, how much of the court's resistance can we attribute to their anxiety about pushing workers, pushing the legislature to kind of include everyone in the Wagner Act model?
Yeah, and that's what I think is the mistake of the judicial formalists, if I can put it that way, of thinking that if we rule in this particular way, we're going to put the Wagner Act or the Ontario Labour Relations Act in cement, and we will never be able to, in the future, find a different, better model for labor relations. I've always thought that's a misleading way of characterizing it. I think it's much better if it said, do these provisions in the legislation, i.e. not permitting first-level managers to be able to unionize, is that a violation of a right to organize? You therefore get away from the idea of is this formalizing the Wagner Act or not, and you're simply looking at it as a constitutional right or freedom as to whether that's being violated or not. I think it's a much simpler way of doing it, and it gets you to better answers. I think less there's no answer, there's no questions, and everybody's probably just exhausted.
Well, it's been a huge amount of information. You've given us a great deal to chew on. I am thankful for coming here to share your wisdom and your knowledge, and I invite all of you to thank Professor Lynk for coming today and serving us.